immigrationquestion.com, your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello, everyone, and welcome to the special webinar edition hosted by immigrationquestion.com, a networking platform and meeting ground where immigrants, families, advocates, and licensed immigration attorneys come together to understand U.S. immigration policies and procedures better. I'm your host, GB Satusa. For this important session, tech layoffs and H-1B status. What happens to your visa if you lose your job in the US? Now, in recent years, layoffs in the tech sector have created uncertainty for many foreign professionals working in the United States under H-1B status. Because employment is directly tied to immigration status, job termination can raise urgent questions about timelines, legal options, and steps. Understanding how the grace period works, what immigration options may be available, and how to plan during uncertain times can help professionals protect their status and avoid complications. Pardon me. Now, to help us break this down, we are honored to be joined by attorney Upasana Goel, an experienced immigration attorney who advises technology professionals, international employees, and employers on employment-based immigration matters, including H-1B compliance, transfers, and long-term immigration planning. Attorney Goel, thank you for joining us today. We're thrilled to have you for this important discussion.
Thank you so much for having me. I'm thrilled to be part of the talk, and I'm looking forward to help as much as I can.
Now, before we begin, a quick reminder to our audience. Immigration Question is a public educational and networking platform. The information shared today is for general informational purposes only and does not constitute individualized legal advice. If you are joining us from Facebook, YouTube, LinkedIn, or any other platform, welcome. Please subscribe and share this session with any H-1B professional and international employees who may benefit from understanding their options during layoffs. Now let's get right into it. Attorney Goel, what happens to an H-1B worker's immigration status immediately after a job termination? And when does the grace period begin?
So there are multiple aspects to the situation. When an employee on an H-1B gets laid off, they get this. That's the general standard, but they also need to see their I-94. So whichever is shorter, that is the time they get to be legally in the United States. We have a few options. In the 60 days or the shorter time, if the I-94 is shorter than the 60 days, they can file for a change of status or they can find a new employer. So that is how it usually goes. If someone in that situation comes to us, the first line we look is for finding a new employer, so they can transfer their current H-1B, petition to a new employer, and they can petition for the employee and file for a transfer. If that is not possible given the current circumstances and the job market, then they have multiple other options, like going on a B1, B2, which is a tourist visa, and find employment while they are on the B1, B2 visa. If they want to study for advancement of their career, they can go on an F1 visa. If their if their partner is on H-1B, they can go on a spouse-dependent H-4 visa. They can look for O1 options, extraordinary ability visas. So those are some few options which people have if they're laid off on an
All
H-1B.
right. And when does the grace period begin?
So the grace period begins on the last
Okay.
day of their pay
All right.
period.
All right.
Uh, so yeah, so the last day for work you are being paid, that is when your grace period starts, the date of your termination. Uh, if that is falling on the same day, so that is something which you should look forward for. And also it is the consecutive 60
Okay.
days.
All right. Now, what options are available during the grace period, and what common misunderstandings do H-1B employees have about this timeline?
So a lot of time, people think those weekends are not being counted and only business days are being counted, but that's not true. It's 60 consecutive days from the date of termination. That 60 days are going to start getting counted. So be very careful about that. And as I mentioned, there are a lot of options. What I would say is whenever you're getting laid off or you are laid off, contact an attorney so they can sit and talk to you about the different options, like going on an H-4 dependent visa, looking for an O-1, filing for a B-1, B-2, F visa, uh, or going back to their home country.
Right. Now, attorney, how does a pending H-1B transfer petition affect a worker's ability to remain in the US and continue working?
So the great thing about filing for a transfer is if someone is on H-1B, they're laid off and they have filed for a new petition or transfer. So if they have done it within those 60 days, which is when they are still in legal status, they automatically go to an authorized period of stay where they can start working once they get the receipt notice of their
All right.
transfer with the new employer.
Oh,
So that is something which covers them. But the important part here is that it has to be filed within the 60 days.
all right.
Once you have once you have filed, you got the receipt notice, you don't have to wait for the new H-1B approval. You can immediately start working.
Now, for individuals with pending approval, pending or approved I-140s, how does a layoff impact their long-term green card process?
This is a very important question. A lot of people are facing this right now. So I'm glad you brought it up. There are different situations with an I-140. For example, on H-1B and their I-140 is already approved. So if it is approved if it has been approved for more than 180 days, that gives them a chance to keep filing for H-1Bs for an unlimited time. So they're not stuck with the 6 year time period. But if your I-140 is not approved for at least 180 days, then you don't get that date with you when it was filed. That's called a PD. Employer within 60 days. Uh, that's something. The 60-day period is with either the 180-day pending I-140 or not, but at least with an 180-day pending I-140, you get unlimited H-1B extensions. So that is something which that helps. An I-140 is a green card for your future job. So if you're not from a backlogged country like India or China, I would say once you get an approved I-140, you should file for a adjustment of status, which is an I-485. Immediately, that really helps. But unfortunately, if you are from a backlog country, I would not be filing for an adjustment of status because there's a long
Yeah.
wait. And also, if someone with approved I-140 has an approved, not approved, a
Yeah.
pending 5, that puts them in a much better situation because they can then change their employer with a supplement J. It's AC-21, and then they do not have to file for a perm again, unlike in a situation where you don't have a pending I-485.
All right. Now, attorney, what happens to dependent family members in H4 status when the primary H-1B holder loses their job?
So the H-4 visa is directly connected to the status of the H-1B holder. The H-4 visa will only be valid till the H-1B is valid. So while the person is an H-1B with an approved I-140, H-4 status is also valid, and they can also apply for an EAD card. But if the H-1B spouse loses their job and they cannot find a new job within 60 days, or if they do not file for any other status, as soon as the H-1B spouse loses a status, the H-4 will automatically lose status. So what I would say is, whenever an H-1B holder has a dependent, and if they are trying to switch their status to another status, you should always with it,
Okay.
the H-4 spouse or
All right. Now, Attorney Goel, in cases where the 60-day grace period is about to expire, what emergency or last resort strategies may be available?
So there are, as I mentioned, a lot of options. There's a list of visas where for, but if you ask me personally, the most practical situation is going for a B1, B2. B1, B2 is a tourist visa where status from H1B to a B1, B2. That there is that you have to be truthful about why you're applying for that visa. That is that you're looking for jobs, and you have to mention that you have been looking for jobs. What effort have you been putting to find a job? If you have any interviews lined up, so it's only like a bridge status, and you eventually do want to move back to H1B. So be truthful about B1, B2 is the best option. The other great option is going on an H4. If your spouse has an H1B, you can always move to a dependent visa on an H4. And if they have an I-140 approved, you can get an EAD and you can continue working.
All right. Now, looking ahead, what proactive steps can H-1B professionals take to protect their status and minimize disruption in the event of layoffs?
I would personally say all the H-1B holders, if they think that they are in a position where they might get laid off or there are some nuances coming, they should always look into an O1 or an EB1A. Those are great visas. They are extraordinary ability visas. You can premium process them. Uh, Once you get an approval, you can file for a green card immediately. There's always also an option of EB2, and right now it is current for almost all countries except I think India and China. So EB2 NIW is a national interest waiver if you are working in a capacity or in a job where you can show impact of how you are helping the American society and people in the US. You can always look for national interest waivers. It has a few criteria you'd like. So that is something which is great option. An EB1A, O1 visa are great. So the majority or majorly the difference is that an EB1 for an O1 you need an employer or you need a business, and O1 is comparatively easier than EB1A, but anyone with an H1B should start looking into all these categories of visas.
All right. Thank you so much, Attorney Goel, for those valuable insights. This is truly an interesting session so far. Now, for everyone watching, this discussion about H-1B professionals and visa status is not meant to create panic, but to encourage preparation and informed decision making. Employment changes can happen unexpectedly, and understanding the legal timelines and available options can help professionals respond quickly and responsibly. If this is your first time joining us, welcome. Immigrationquestion.com, is a networking platform where users can ask immigration-related questions at no cost and engage with participating attorneys. We're also proud to share that immigrationquestion.com is triple B accredited and ISO certified, reflecting our commitment to transparency, accountability, community education, and security. Now, Attorney Goel, based on your experience advising H-1B professionals and employers, how does immigrationquestion.com help immigrants and immigration attorneys like yourself?
It is a great reach out to people who are in help. There are a lot of people right now who status, and especially right now, who are looking to go from F1, especially students, to an H-1B. The H-1B lottery is right now open, filing H-1Bs for a lot of students who are here. So it's a great platform to help people get some knowledge about the visas and about their options. Not only H-1 visas, they can go directly from a student visa. And with the new 100,000 scenario coming along, it is a very challenging visa type. And even the employers are very scared right now because a lot of people don't have the clarity about how the 100,000 will hit them or will not hit them. That is something I think right now a lot of people want to look into.
Yeah. Thank you for those thoughts, Attorney. Now, before we move into our live Q&A session, I have one more question that we should tackle. What is one common misconception about H-1B layoffs and visa status that you believe foreign professionals should clarify to avoid making risky decisions during job transitions?
So with H1 right now, I would say the landscape. A lot of people think that once they so because the regulations are not very clear around H1Bs, and there are a lot of new regulations coming. For example, when people are moving to a new H1B from a different visa category, they think one if they go back to their home country, they would just get a visa stamp and come back. But fact that would they be hit by 100,000 or not? Because it's the first time. So I am telling all people who are right now on H1B, transferring to a new H1B, clear answer. So with every individual, the attorney has to sit and find possibilities if they might get stuck in their home country or if they wouldn't. Straight jacket formula of who would be or not be subject to the 100,000 fine. That is something which I think right now there's a lot of confusion and people need to understand that.
If you've just joined us, we've been speaking with attorney Upasana Goel on tech layoffs and H-1B status. What happens to your visa if you lose your job in the US? We are now moving into our live Q&A session. This is your opportunity to ask general questions and hear educational insight from a licensed immigration attorney. Please drop your questions in the chat or call us live at 516-703-3483, and we'll take as many as time permits. All right. I am not seeing this question properly. Will the 60-day grace period start? Will the 60-day grace period start the day my company tells me I'm laid off or my last day of work?
Will start the day you last work because they can tell you a week prior, but on the last day of your work, it's the day you will start account.
All right. If I find another employer quickly, do I need to go through the H-1B lottery again? I really hope not.
Congratulations. If you have found an employer quickly, not have to go through the lottery again. If you're already working on your H-1B and your status is already active, you're already into the lottery, and you can transfer as many times as you want with your employer. They do not have to go back into the lottery.
Okay. Can I change to another visa, like a visitor visa, after a layoff?
Yes, you can change into a visitor visa, that is a P1B2 after a layoff. Caveat here is be very truthful about why you are changing into a visitor visa, what you would be doing while you are, and while applying for a visitor visa, also show that you have enough funds in bank account to sustain it without any illegal work.
All right. Now, attorney, many international students move from F1 status to H-1B employment after graduation. Can you explain how the change of status process works when an employer files the H-1B petition from within the United States, and what students should understand about things like cap gap protection, the difference between change of status and consular processing, and whether fees apply to those changing status inside the US?
Okay,
Yeah,
questions together.
sorry about that.
You're fine. So someone is in the US on an F1 visa and they start looking for jobs. So they have to go, if they want to go for an H-1B visa, then go get into the lottery. The employer files for that person. It can be an employee or it can be someone not an employee and they want to. So that person has to go into a lottery. Right now, selection. So depending on you will be selected in lottery. So once someone is in lottery, then it is which is an I-129. They file for the person, and once the I-129 petition is approved, that is when you get an H-1B status. H-1B status, you need to start working with that employer on your new H-1 status. So that is when you transfer from an F1 to an. So there are two ways how status gets activated. When United States with a with a stamp of H-1B, that is when CBP admits you on an H-1B, or when you change United States and you start working for the employer, that is when you're admitted to the H-1 status. So that is change from an F1 to H-1B. So first the lottery, then the I-129 petition. If it's approved, you start working with a change of status and you come on the H-1B status. The second question was
So what students should understand about things like cap gap protection, the difference between the
cap gap.
Yes.
So what a cap gap is that you don't have to actively.
Sorry about that. Let me just re-ask that. And what students should understand about things like cap gap protection and the difference between the change of status and consular processing?
So for cap gap, you don't apply for cap gap. Cap gap gets automatically it comes if the employer is filing for a change of status. So I can explain that. For example, the employee's student visa, the OPT or the STEM OPT is expiring in May or June, and the employer had already filed for a change of status in April. So the employee gets a question automatically till October, 1st October. So that is what cap gap is. Cap gap essentially means that the person does not fall out of status and they already have got an extension to work till October 1st. So that is something which is very important. Very important facts to how to get a cap gap is that the employer needs to file a change of status. If they do not file for a change of status and they file for a consular, there is no cap gap. Then the student needs to go back the day their OPT is expired or after 60 days, which is the grace period, back to their home country and get a new visa stamp and then come back. So cap gap is essentially lying on the fact if the employer has filed for a change of status in the I-129 petition or for a consular. So that is something students need to be very careful about when their employer is filing for them, to make sure they tell them for a change of status. And about the 100,000. So the proclamation has made this one thing clear. If you're changing your status from any status to an H-1B within the United States, you are not hit by the 100,000 fee. So it's a great time for anyone who is on an F1 OPT or a STEM OPT. They can transfer to an H-1B if they get selected in the lottery, and they will not be hit by the 100,000.
All right.
But for someone who's outside the US, they would need to pay 100,000 to get someone to the US.
Okay.
Because that would be consular processing.
All right. Thank you to everyone who joined us for this special edition webinar, and thank you, Attorney Goel, for sharing your knowledge and practical guidance with us today. You can always visit immigrationquestion.com to ask immigration-related questions, stay informed about policy updates, and register for upcoming live events. If you missed any part of today's valuable discussion, the replay will be available on Spotify soon. Search Borderless Talk by immigrationquestion.com. We look forward to seeing you on Tuesday at our next live session. Until then, stay informed, stay prepared, and stay connected. Bye-bye.